Now, a lot of people around the world are not so lucky like most of us in this room. The UN Commission on Legal Empowerment estimates that there are about 4 billion people across the globe who live outside the protection of the law. And in a survey that we did in Sierra Leone in 2010, 35% of the respondents said they had a legal problem for which they could not find a solution. That is very grave for any society, and that is very grave for social cohesion purposes. So there are so many people who live outside the protection of the law, and most of those people are poor, marginalized, and vulnerable people in most cases. Now, the general conception of law is that it's supposed to be that golden thread that holds the community together. But for many, like the 4 billion that the UN estimates, the law is actually just an abstraction. In some instances, the law is even a threat to poor people. And many poor people's experience with the law is quite negative. So that a whole lot of people who are excluded from the protection of the law and they view the law from a very negative perspective. Now, as an organization, the Open Society Foundation supports a number of initiatives that aims to expand the frontiers of access to justice to the most marginalized populations. And today, I'm going to be sharing with you two of the models that we support. And these models have nothing to do with the classic legal aid systems that we have in most of our countries. Obviously, the problem of access to justice is not limited to Nigeria, it's not limited to West Africa, it's not limited to Africa, it's a worldwide problem. And so there have been a number of organizations and of course government trying to explore various ways of bringing justice, making justice more accessible to the highest number of people possible. So OSF supports these kind of initiatives, and I'm going to share two examples with you of legal aid models or legal assistance models that we support, one in Sierra Leone and another one in Senegal. Now, in Sierra Leone, you will recall that the country had a very long and destructive civil war that completely crippled the justice system. And because the justice system was crippled, lawyers in Sierra Leone started looking for solutions to the justice needs of the population. The fact that the justice system was crippled never stopped disputes from arising between community members. And those disputes needed to be settled. So some brilliant lawyers in an organization called Team Up for Justice started a network of paralegals. Because of course, there were not enough lawyers in the country to meet the justice needs of the people. The courts were not working. And if there were lawyers, they were mostly based in Freetown. And those who were based in Freetown, of course, their services were very expensive, way beyond the means of ordinary people. So these lawyers started a movement of paralegalism, if I call it that way. And paralegalism was meant to solve problems, legal problems through conciliation and mediation, and in some extreme cases, through litigation. Now, the model that we are supporting in Sierra Leone, we call it the Legal Empowerment Shared Framework. And when we say legal empowerment, we mean three things principally. The first thing is to make sure that individuals and communities understand the law. We hear it every day that ignorance of the law is no excuse. But ignorance of the law is real. A lot of folks are not educated legally. Even trained lawyers like most of us in this room do not know all the laws. What more of those who are not educated? So what we envisage as part of this legal empowerment shared framework is to make sure that legal education, basic legal education and precepts are grasped by a large proportion of the population, and we concentrate on rural areas. And I'll come back to how we do this. The second thing that legal empowerment does is to help individuals and communities use the law. When you know the law, it's not enough. You need to be able to use the law to actualize a right. And the third thing that our legal empowerment work does, it helps individuals and communities to shape the law. Now, when you know the law, you use the law, the next thing you do is to discover the deficiencies of that law, the shortcomings of that law, the gaps that exist in that law, and take measures to shape it. And you shape it through various means. It could be that through your experience of using the law, you gather data that shows that the law is detrimental in its application to various populations. And using that data, you can use that data to do advocacy for that law to either be amended, to be repealed. And by so doing, you are actually shaping the law and completing your experience with the law. So you know the law, you understand it, you use it, and you are able to shape it. And when you can do these three things, we say you are legally empowered. Okay. Now, in Sierra Leone, our interventions are at three basic levels. The very first level, as I said before, is that we support community legal education, which is legal literacy. And it helps communities to know, use, and shape the law through their experiences. And because there are not enough trained lawyers in Sierra Leone, we are working with the Sierra Leone Legal Aid Board, which was set up in 2012 through the Legal Aid Act. And there is something that is very interesting about this Legal Aid Act of 2012 in Sierra Leone, and it's quite unique amongst legal aid schemes across West Africa. Now, the Sierra Leone Legal Aid Act recognizes paralegals as primary justice service providers. This is very significant. I recall that when the bill for this act was proposed, a lot of lawyers opposed it because they thought that recognizing paralegals as primary service justice providers was going to dilute the role of the legal profession, because it was going to bring in amateurs and people who were not well schooled in the law, and it was going to take away their exclusive, of course, their exclusive rights over providing justice services. But what happened was that the organizations that advocated for this clause to be included in the law were able to persuade Parliament that actually paralegals were going to enhance the business of the lawyers. Because these are the guys who are going to be in far-flung communities. These are the people who are going to discover legal issues in communities where lawyers don't exist. These are the people who do the footwork in places where there are no roads, where cars cannot access, and bring this information to lawyers. Of course, the Act does not give the paralegals free rein. They work under the supervision of senior lawyers to maintain quality. So what paralegals have actually done in Sierra Leone is to increase or improve the business of the established lawyers, because they bring more cases to their attention. And so I saw in one of the presentations that Nigeria has a legal aid act I have not read that act. I don't know its provisions, and I don't know what the place of paralegals is in that act. But the Sierra Leone model is very interesting in the sense that it gives paralegals some role as primary justice service providers. Sorry. So I've talked about the first level of our interventions. The second level is helping these paralegals to be able to settle common disputes within communities where there are no established justice structures. And these paralegals, in this sense, play a dual role. They can either engage in mediation or conciliation, or they can refer the various litigants to the relevant jurisdictions where their case can be resolved. And the third level is using the information that paralegals obtain from their practice in the field to feed into the processes of the National Legal Aid Board, and they have what they call the Justice Coordination Sector, Justice Coordination Sector Office, something of that kind, which is in charge of proposing laws for reform. So the information that paralegals gather at community level fits into some of these, fits into the processes of this Justice Sector Coordination Office in terms of what laws need to be reformed because of the experience that paralegals and sometimes lawyers have had in the experience they've had in using a particular piece of legislation. Now, there are a particular number of issues that paralegals deal with in Sierra Leone, which are very, very fundamental. And these are not issues that are peculiar to Sierra Leone, but I think they run across West Africa. Now, environmental issues. Sierra Leone's economy is based primarily on mining, and there are a plethora of mining companies that have invaded that space. They invade the space and totally and completely disregard environmental regulations. And sometimes the communities where environmental degradation is happening do not know what to do. They simply don't know what to do. They don't even know whether there are regulations that exist that prevent companies from degrading the environment. But what has increasingly been happening in Sierra Leone now is that because there are paralegals in most of these communities, whenever there is a case of environmental degradation, paralegals bring this case to the attention of lawyers in Freetown. And for those who've been following jurisprudence on Sierra Leone, there are a number of companies, quite a good number of them, specifically Chinese companies, that have been fined very heavily through the work of paralegals and lawyers because of the impact that their activities had on the environment in the areas where they operate. Of course, there are also agricultural companies that grab land. There's a lot of land grabbing that goes on. They come in with a piece of paper, maybe get the chief of a locality to sign off huge tracts of land without any due regard to the existence of any rules or regulations or laws, no kind of consultation with the community, and the land is grabbed. A number of these cases have been resolved through the work of paralegals and through strategic litigation. I don't know how many of you have heard about Namati in Sierra Leone. Namati. You've heard about the incredible work that Namati paralegals do in terms of fighting against land grabs and environmental degradation. That is just what paralegals can do when they're empowered to know, use, and shape the law. And of course, there are citizenship issues and forced evictions that are very, very prevalent in most parts of rural Sierra Leone that paralegals deal with on a daily basis. Now, it's a very elaborate, very, very elaborate scheme, very well organized scheme. All these paralegals, they must be accredited first by the Legal Aid Board. It's not just anybody who gets up and says, I want to be a paralegal, and they become a paralegal. They need to go through a specific training. and be accredited by the legal aid board for them to be qualified to serve as a paralegal in any community. And if you go online, you'll be able to see the act and how it actually works in practice. And if you go on the website of NAMATI as well, you should be able to see the number of cases that they have done through public interest litigation that has helped a lot of communities to recover their land, to gain compensation from land that was grabbed by companies and a lot of other things. So that's for the Sierra Leone case. Now, there is a course which the Open Society Foundation organizes every year in June in Budapest. It's called Legal Empowerment Leadership Course. I believe that a lot of people in this room are qualified to take that course. It comes with a scholarship, and I want to encourage all of you to check up on it and apply. It is a very, very important course that brings together paralegal movements from across the world to share their experiences on the work that they do within communities. It's not only paralegals, it's also, established lawyers. So I will encourage you to check out their website, NAMATI, or the Open Society Justice Initiative website, where you can see information about the course. It happens every June in Budapest, Hungary, and most of the time it's fully paid for. Now, the next model that I want to share with you is in Senegal. Senegal, like most West African countries, has this duality of legal systems. So there is a formal legal system with the classic courts, magistrates, lawyers, and the rest, and there's the informal sector, the informal justice sector, which is mostly run by traditional leaders or religious leaders. And what has happened in Senegal is that, and this is from a study that we carried out sometime in 2008. What happens in Senegal is that we discovered that a lot more people were using the informal structures than the formal structures of justice. And part of the reasons people gave for preferring the informal structures was because, first, the complaint about the cost of the formal justice system, the complaint about its procedural rigidity and processes which they did not understand, and the complaint about the length of time that it took for matters to be resolved in formal court. That is not the case with informal courts. Matters go quickly, they understand the process, they participate in the process, they use a language that they know. Obviously, in the formal court, it's French, and if it's this place for translation, sometimes the translation is really terrible. So people mostly prefer a system where they understand, first of all, they understand what is going on. It's their language that is being used for adjudication. And at the end of this process, they feel that they get justice because they understood the process, they were heard, they were not represented by lawyers who spoke all the time on their behalf. There was no intimidation. Our courtrooms are built to be intimidating. For those who are not used to the system, a courtroom is very intimidating. Lawyers all clad in suits and wigs and all of that. Any ordinary person coming into contact with this system is intimidated. We use legal jargon that ordinary people don't understand. You're talking about their case and they have no idea what you're talking about. At the end of the day, there is a decision that they have to follow. And in their eyes, that decision will always remain illegitimate because in most cases, they don't feel that they actively participated in the process that led to that decision. But it's different for the informal systems. So the deficiencies of this formal system engendered a thought process within the government of Senegal where they now started devising means of being able to link up the two systems. So obviously, the formal justice system has its own advantages. There's precedence, there's certainty, there is a defined law, there is record keeping and all of this. All these things are not present in the informal system. The informal system, on the other hand, sometimes, most of the time, they don't respect the rules of natural justice. And women, especially who come into contact with these informal justice systems, are not treated fairly. So there's an issue of fairness with certain populations in the informal justice system. So this engendered a thought process within the government of Senegal, and they said, let's look for a system that is midway. A system that takes advantage of the flexibility, legitimacy, and informality of the informal structures, married with that of legality and some form of formalism, record keeping, and certainty to create a unique system that will afford access to justice to a greater part of the Senegalese population. This they call justice de proximité, like proximity justice. And this led to the creation of what they called Maison de Justice. Maison de Justice, literally translated, will be like justice houses. Now, so the justice houses were essentially introduced to bridge that gap between the informality of the informal systems and the formality of the formal system, taking advantage of the positive aspects of both while trying to simultaneously eliminate some of the various deficiencies. And I must say that it's not across the whole of Senegal where you have this Maison de Justice. Today, we have just 18 operating across the whole of Senegal. And the government follows strict criteria to be able to locate a Maison de Justice in a particular area. The very first criteria that it uses is the size of the population of the area and its remoteness from an established jurisdiction. So there are population centers where there's no formal cost structure. And so the government tries to locate a Maison de Justice in some of these areas. Secondly, they look at the level of economic activity in that area. Normally, where there is a higher level of economic activity, you would expect a higher number of disputes between community members. So they look at these two issues, the size of the population of the locality, and of course the economic activity in that area, and then they will make a decision to implant a Maison de Justice in that area. But the functioning of Maison de Justice is guided by a number of principles. One is that of spatial proximity, which I have mentioned as it being physically situated where there is a high concentration of a population or high concentration of people. And normally, this is in semi-urban areas and rural areas where there is some level of economic activities. Secondly, the Maison de Justice use local languages, and they use very minimal formalism to ensure that language barrier does not complicate proceedings. And in this court, the only process that is allowed is mediation and conciliation. So Maison de Justice, they exclusively do mediation and conciliation, which are recognized means of traditional conflict settlement in England. And then the third, which is most important and at the core of what we're talking about here, is that of gratuity of service. All the services that Maison de Justice offer are free of charge. And the cost of running the Maison de Justice are borne by the Ministry of Justice and the local municipality. And this brings us to the next principle under which it functions, which is that of partnership. Now, a Maison de Justice can only be situated in an area where the local municipality, which I think here you will call local government area, agrees with the Ministry of Justice that they will co-fund the functioning of the Maison de Justice. And this is very important for its legitimacy, because it is the people of the area who own the Maison de Justice. They are the ones who coordinate its activities. Now, what is the mandate of this Maison de Justice? I've already mentioned it, but its principal mandate is that of settling disputes between community members based on mediation and conciliation, even if, I must add this caveat, the litigants are not bound by the outcome of the mediation. They are not bound. If there is a mediation process and you're not satisfied with it, you can take your case to the formal court. Now, the Maison de Justice handles principally civil matters, so issues such as debt recovery, rent-related disputes, land matters, small family disputes, service contracts, neighborhood disputes. Those are the kind of small kind of cases that the Maison de Justice handle. They also handle simple offenses that do not need, where punishment, the prescribed punishment for which is not a term of imprisonment. So simple offenses where the punishment is fine are also handled by the Maison de Justice. But the Maison de Justice is under an obligation to bring to the prosecutor of the area where they are situated any serious matter that is brought to his attention. So if a woman brings a case of rape to the Maison de Justice cannot handle rape. It must refer that case to the prosecutor. And one very important function of the Maison de Justice, and this is very peculiar to Francophone countries, the issue of administrative documents. Maison de Justice help the community members to procure administrative documents and documents of civil status. So you have your birth certificate, your marriage certificate, your identity card, your certificate of non-conviction. The Maison de Justice helps to do this. Okay, so I'm told that my time is almost up, but what I just want to point out why the Maison de Justice are so important in terms of access to justice. Normally, there are a lot of these small cases that come to the formal justice system and help to unnecessarily clog it up and prevent the formal justice system from handling the most important cases. And that is why sometimes we have lengthy pretrial detention because there are not enough magistrates to handle the cases. We have people languishing in jail waiting for their cases to be heard, but there are just not enough magistrates. Now, what the Maison de Justice does is to take away some of these very minor cases that clog up the system and deals with it in a conciliatory manner. If you've been following the evolution of pretrial detention length in Senegal, you realize that in the past 5 years, they have reduced considerably, and the Maison de Justice are partly responsible for that reduction in the length of pretrial detention because the courts can finally now concentrate on the more serious cases. We have enough time for discussion. I think it will be better if I take questions for clarifications so that if there's anything that I left out, we should be able to discuss it in the next few minutes. Thank you all very much.
Thank you very much. Please, any questions or contributions?
Thank you. Actually, I want to, when we were making your presentation, you mentioned Nigerian League Council of Nigeria, Council of Nigeria Act as amended. Actually, the law has provided recognized legals. It is not provided under the Act as one of the providers in Nigeria. The law was actually provided also also, the law has mandated any council of Nigeria to also supervise, certify them. And the issue has been, as you said, there has been I think last year when the Litigation of Nigeria tried to validate their level in the strategy document, where some of these issues came up, trying to set up the framework for that supervision, also how to certify them. And but the issue has been that mostly the providers that you are talking about is actually those from community-based providers. These are the people at the village that do that discrete level services, which within the villages where there's no lawyer, they do that and then come to possible law firms and civil society, maybe that provide service. And those ones, most of them may not have that technical ability to go to the formal. So, but that is different from what they actually act. The act was more of trying to, in America they have a provider, but their own provider is like nurses. So they are more formal also. So there is this kind of dichotomy between community-based provider and those formal providers that work with the lawyers, or work with the legal-based organizations. And also, Nigeria law has also provided for that. I'm telling you that we have what they call National Innovative Diploma in Paralegal Studies in Nigeria now, which under the NBTP, we have the agency that I have the group over here, where the idea for that one is to provide for those paralegals that will now can work with lawyers in the law firms or work in the courts or other places. It was meant to create more employment opportunities. So that is another step. So that is issue of the community-based one and those high-level paralegals. So and the challenge has been how do we reach that gap? Because those community-based one doesn't have a standard curriculum. The both one that MPT I talked about has a different curriculum, the way what we're going to train them. So most of the society that we using paralegals in Nigeria have just been those informal training ones, which they use as of this age to try to the So actually many appeals in Nigeria do that. But the talks have been on how we standardize those community paralegals, the operational factors.
Thank you very much. I want to sincerely commend the level of information we just shared to us relating to Sierra Leone and the Senegal. My colleague here has tried to establish that in Nigeria there are some variation of paradigm, but I want to say that from what we have listened to the experience in Sierra Leone and Senegal, Nigeria is still a far cry from taking justice to those who actually need it, to those who are poor and who doesn't belong to a formal system. Even the legal we are talking about is basically from the formal system. Like lawyers, law offices, NGOs, organizing or arranging free legal services, maybe in the villages. But most of these things are concentrated in cities. I think there's a legal void, as far as Nigeria is concerned, on this issue of getting the community to participate in paralegal services. So that in this country, if you have any dispute regarding ordinary, somebody is owing you 50,000 naira, instead of having a place to complain, many of them rush to the police. We see the police detaining people for ordinary death, simple death. No other access to justice apart from the formal sector. That is the situation we have in this country. And so that even the customary arbitration that is supposed to be, provide some support in the villages where the community leaders, village leaders, elders, the council sit over matters, very simple and even sometimes criminal cases and civil cases. The situation in Nigeria, I'm coming from a village, and I know that every Nigeria is a villager. Even those from Lagos Island or maybe are villagers, if you have gone to Lagos Island. And so the system of justice in this country at that primordial level still remains that corruption and infiltration everywhere. There are many cases in my village where the village elders take pride to preside over village matters. So there are no paralegal, even the village second customer arbitration is still neither here nor there rendering justice. So I want to sincerely say that this country, we need to learn so much. And lawyers here, especially those of us in a civil society organization, we need to start thinking, the homegrown justice outside the formal sector. Now, when you started your presentation, you were asking, is there anybody that has suffered injustice that didn't have solution to it? All of us kept quiet. It's because we're thinking either individually or otherwise, or because from lawyer's point of view. But I want to say that in this country, many of us who are lawyers have had the unfortunate situation of being put in a situation of helplessness. Now, what they do in this country, I stand to be corrected, is that if they know that they want to grapple upon your legal rights, they will ask you to go to court. They know that what they are doing is wrong, but they will do it and ask you to go to court, especially from government sector. Then it will not take forever. Sometimes they go and put you inside police cell. It will take another 2 weeks before a lawyer can go to court and bring you out. That is just the beginning, arraignment. When you come out of detention, you now wait for the police to complete the investigation before you are arraigned, before the process up to Supreme Court. Okay, this NP election we just finished. We know that all of us lawyers were not happy with what happened. And now all of us are helpless. And we're not saying that we have had in this situation that we are helpless. So there are so many. Now, the nearest that we can get to the situation in Sierra Leone and Senegal in Nigeria is the initiative now being taken by state high courts by establishing what is now known as the multi-court houses. These multi-court houses, as much as possible, the cases in the high court are screened so that those that doesn't really require to go through full litigation will be assigned to multi-court house. There is also the walk-in system where if you are grieved in any way and you don't have a lawyer, you can just walk in on your own. Even if you are illiterate, they will give you someone that will interview you and take down your claim and invite the other side. But what I now learned is that the cost of even this multi-court house is supposed to be free ordinarily if it is conceived properly. But in this country, it is not free. You have to pay. One of my students, the PhD student, told me that I have to abandon a multi-court house procedure that referred him to because he couldn't pay the cost. To that extent. So what we're saying is that in this country we need to do more. All of us need to do more. We should not be thinking only of the formal system. But justice is what is justice when it's just a fencing game? Finally, we were talking about the need to educate committee members because ignorance of the law is not an excuse. But I want to say all of us are lawyers at a different level. I want to say that a lawyer being knowledgeable in law is just a presumption. It's presumed in our favor. But in a real situation, when the chiefs are down, we find that an average Nigerian lawyer don't even know up to 1/50 of Nigerian law. Just look at a collection of Nigerian law of tradition Nigeria 2004, and know the amount of law inside. Before you now begin to talk of the case laws, before you begin to talk of other laws. So the only difference between a lawyer and others is that once you have a place to go and read it up, you know where to find it. You know where to find it. But if it's for a lawyer to stand up and do a smart, off-the-cuff discussion of maybe admiralty law, you cannot really do it. And it's a closed practice, for instance. So all of us need this, legal education, either formally or informally. Let me stop here. Most of life.